the difference. Radio 786.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم Assalamu alaikum wa rahmatullahi wa barakatuh and everyone welcome to another edition of On the Couch with me, Zainab Bean. On the Couch aims to unpack, deal and discuss issues that we don't often want to address, but issues that most certainly affect you or those close to you. So let's hear the difference here on Radio 786 and 100.4 FM. Now, of course, this is our weekly advice assembly, and just to give you an idea of what an advice assembly is, an advice assembly is usually a weekly meeting of tenants, occupiers and activists hosted by Reclaim the City and Ndifuna Ukwazi. It is also a space to learn about eviction laws and also our rights and responsibilities as tenants, and to stand in solidarity to prevent and resist unlawful evictions and unfair landlord practices. Social solidarity and sharing knowledge is even more essential now in the wake of COVID-19 pandemic and massive economic hardships facing the country. And during this weekly on-air advice assembly, we will cover topics like what the current position on evictions is now that the state of disaster has come to an end, also tenants who cannot pay rent and what to do as both the landlord and the tenant, unlawful evictions and what to do if you are being unlawfully evicted, various ways your landlord can harass you and what can be done about them, cutting services like electricity and your water supply, some of the responsibilities of bodies like the police, the court and the Rental Housing Tribunal, and also early cancellations of a lease. All of that will be discussed in our weekly assembly here on Radio 786 here on The Couch with me on a Thursday evening, inshallah. And of course, today our main focus is to look at the courts that can be very expensive, looking at what really is the role of the Rental Housing Tribunal and its functions to society. Now in studio, I'm very happy and pleased to be joined by Mpho Raboeane, who is no stranger to the airwaves of Radio 786, but also joining her is Sibongile Morara, who is the Deputy Chair of Rental Housing Tribunal, and both of them joins me. Remember that our lines are open on 021 699 1786. You can also WhatsApp your comments or questions to 0786 10 11 12. That's 0786 10 11 12. Remember, the focus is looking at what is the Rental Housing Tribunal and also its functions to society, if we look and take into consideration the fact that courts can be very expensive. But for now, let's welcome Mpho and also Sibongile. Thanks so much for your time and thanks for joining me.
Thanks, Zainab. Thanks for having us.
Thank you so much. Thank you for having me.
Absolute pleasure. Now, the focus, of course, looks today at the fact that courts can be very expensive. And now we obviously know, and we've heard so much about the Rental Housing Tribunal and its functions to society. So I think the very first question that we can maybe just get out of the way is, what really is the function of the Rental Housing Tribunal? And I'm going to direct that directly to the main speaker today, who is, of course, Sibongile Morara, who is the Deputy Chair of the Rental Housing Tribunal.
All right. Thank you for having me. My name is Miss Morara, Deputy Chairperson of the Western Cape Tribunal. I think the main purpose of the tribunal is to try and resolve disputes between tenants and landlords, is to try and balance the rights between landlords and tenants and to protect both of them against any unfair practices or exploitation that may happen. So how we facilitate that is any party may lodge a complaint, obviously a landlord or a tenant, and it's a free service. And the reason why it makes it much more accessible as compared to our conventional courts is because they don't need any legal representation. So you're allowed to represent yourself at the tribunal. I think that's the most distinct a difference from your magistrate courts and your high courts.
Now, for the last few weeks, we've been discussing the case of Megan, who lives in Kuils River, and she has a 3-year-old daughter, and heard of the Rental Housing Tribunal during the course of the eviction proceedings, in which her landlord took her to court. And when the magistrate looked at the notice to vacate that the landlord had given Megan, they said that they must first go to the Rental Housing Tribunal. Now, the magistrate thinks that the notice to vacate may be an unlawful notice. Now, Megan, of course, was at this stage quite confused. She had no idea what the RHT, or the Rental Housing Tribunal, was and what its functions were. Now, can Megan afford the Rental Housing Tribunal, and how do they basically function, and what would they do specifically with a case like Megan's?
So, Zainab, in Megan's situation, firstly, let's address why the magistrate would have thought that the notice to vacate was unlawful. We would know that in terms of the Rental Housing Act, and also now as enshrined by some of our case law, a notice to vacate must afford a tenant at least 30 calendar days to vacate the property, nothing less. And anything less than that would then be considered an unlawful notice to vacate. So I suspect that's the inkling that the magistrate would have gotten from looking at Megan's case. Now, referring her to the Rental Housing Tribunal would benefit Megan because, as Ms. Morara has already said, there's no need for legal representation, which already cuts the cost factor considerably. But the other major thing is that the Rental Housing Tribunal is free. So Megan would have no barrier to entry in terms of cost for her to access the service. And as Ms. Morara has already outlined in terms of the services they provide or how they could assist Megan, they would then take on her complaint, which she would register as an unlawful notice to vacate on their forms. They would look at that, they would investigate that, and they would then look at either facilitating a mediation, or where that is not applicable, or if the mediation does not work with her landlord, then they would go into a hearing or an adjudication.
Okay. Now, here's a question. Is the Rental Housing Tribunal only for tenants, or can landlords also approach the RHT?
Yeah, I think I just said earlier that it's for both of them. It's for both tenants and landlords. But I know there is a general feeling, I don't know what to call it exactly, but there are some people who think, or more inclined to think, that it's just for tenants.
Yes.
But really, it's
for both.
It's for everyone, yeah.
Now, when you approach the Rental Housing Tribunal to get, you can also do so just to get general information. Is that correct?
Yeah, you can go there at the inquiries. There's a help desk. So you can go if you want to find out more, or you can go online if you want to do research. So it's definitely open to the public.
I want to just discuss and go through what would be called unfair practices from a landlord. If we can maybe just go through some examples, or just define what an unfair practice will be according to the Rental Housing Tribunal.
Okay, so in terms of the Rental Housing Act, which is the act that also constitutes the Rental Housing Tribunal itself, an unfair practice would be any contravention of that act. And contravention would basically just mean if you go against anything that is set out in terms of that act, okay? And then an unfair practice is also defined as a failure or an act or an omission which prejudices the rights of the other, being the landlord or the tenant. Okay. So if you look at it wholly, it's either a contravention of the act or an act or omission that prejudices the right of the other party.
Okay. You are listening to Radio 786 100.4 FM, and if you have just joined us, a very warm welcome. It's On the Couch. We are looking at courts that can be expensive, and really what is the Rental Housing Tribunal and also its functions to society. In studio, I'm joined by Mpho Raboeane and also Sibongile Morara, who is the Deputy Chair of the Rental Housing Tribunal. Now, I do understand, and here's a question, and I know earlier it was mentioned that the Rental Housing Act says that a landlord must give a tenant at least 2 months written notice. Now, this person says in the WhatsApp message that I was given only a month's notice, not even a complete month. What can be done in a case like this?
Okay, so it all depends on what they contracted on. What does the lease agreement say? So if they contracted on, it's a 2 months notice period, or it's a 1 month notice period, but our act provides for only 30 days notice, 1 calendar month notice period. So I would advise this person to lodge a complaint if they're unhappy in the manner in which they've been handled by landlord to lodge a complaint with the tribunal so the matter can be mediated. Obviously, mediation means a voluntary process where parties sit down around the table and try to resolve the matter. If it cannot be resolved via mediation, and then the matter is then transferred to a hearing.
Okay.
So in that particular instance, I think the first document to look at is the lease agreement, and to look at the terms in which they agreed on. And then obviously the Rental Housing Act also would trump the lease agreement. Yeah.
Mpho, you want to add to that?
No, I think Ms. Morara has covered everything there. I think there may be a slight confusion in terms of the periods. I think the listener asked about 2 months, whereas Ms. Morara has just clarified that the Act only states that 30 calendar days in terms of notice are required for a notice to vacate to be lawful. The requirement that does require 2 months notice is actually around the increasing of the rental amount. So you would know that in your lease agreement, it may be subject to an annual increase of rent. We're used to figures like 10%, 15%, thereabout. But the 2 month period is there because it's to allow the tenant enough time to adjust. So should the increase be outside of the annual increase in terms of the lease, and should the increase be something other than what was agreed to in terms of an increase in terms of the lease, then that 2 month period notice would be required of the landlord.
Okay. 0216991786 or 0786 1011 12 if you'd like to be part of our conversation. I have in studio Mpho Raboeane as well as Sibongile Morara, who is the Deputy Chair of the Rental Housing Tribunal. And we're talking about what the Rental Housing Tribunal and its functions are to society. Now, here's a few WhatsApp messages, and one of it actually asks, when I signed my lease, the agreement on the lease is that it comes with water and electricity, and now after 5 years of staying here, I've been told that now I have to pay for water because of my water usage. What can be done in this case?
Okay, in this scenario, obviously the landlord would have to approach the tenant with the view of altering the lease agreement, because in effect that's what it does. It alters the conditions and terms of the lease. And if the tenant agrees for these conditions to be altered, then it should be fine. But then the problem starts when the tenant refuses to accept those changes, for example, for paying for water and electricity, because
it wasn't part of the initial lease.
Yes. So in that instance, they would be allowed to lodge a complaint for unilateral changes of the agreement. And I mean, at the end of the day, it's all about bringing some kind of a resolution between the parties, because the landlord is asking for payment for water and electricity, while the other party will most likely will not accept that, or to some extent would like to negotiate that. So in that instance, the tenant would also be able to file a complaint with the tribunal.
But I do see at the end of the message, the person did say that it is as a result of the tenant's water usage. So in this case, couldn't the landlord maybe have a point in terms of why they want to have them pay because of how they use the water?
Look, it's standard practice generally that tenants pay for their own water and electricity. But you do find those isolated situations like that one, the water and electricity is included. You know, so basically it's just to have both parties to sit down and communicate in how they can solve the issues. And obviously you need the landlord to come to the table and say, but this is how we're using the water excessively, and maybe try to deal with that issue if that's the problem.
Okay. Here's one more question. My rent was increased based on my water usage as well. So now my rent has been increased after a year, also based on the fact that I'm using more water, but water is not essentially included in is included in the rent.
Yeah. So
But
that
the rent increased. The rent basically increased, although water was supposedly included. But as a result of how this person is also using the water, the rent now increased based on that. Is that allowed?
once again, that sounds like a unilateral change to the agreement that is not allowed. The landlord first needs to inform the tenant, give a notice to the tenant, renegotiate the terms of the lease. The tenant may accept, may not accept. If they don't accept, they are welcome to file a complaint for unilateral changes to the agreement. So it's actually not allowed for a landlord to charge a tenant extra costs if they are not reduced into writing as per the lease agreement.
Radio 786 100.4 FM. Our lines open 021 699 1786. Send your comments to 0786 1011 12. Assalamu alaikum. We are staying in a house that we rented for about 5 years from the owners that are both dead. There is no will. We pay the rent to the brother. We're fixing the place ourselves. We just want to know what we can do in this particular situation. So I'm assuming that the landlords passed on, and now the brother stepped in, and they're now paying the rent to the brother. But they're fixing the place, etc. How does it work?
All right. So this would be dependent on what relief this couple is actually looking for. If it's a matter of questioning the authority of the brother who's now stepped into their previous landlord's shoes, then there would have to be questions around reconstituting a lease agreement if necessary, but also looking at whether or not the brother is now the lawful owner of the property, and whether in terms of the act he has the authority to act as a landlord and accept monies for offering that accommodation. Another aspect there is with respect to improving the property. Again, your first reference point would be the lease agreement, but generally speaking, improvements upon the property are not allowed in a situation of tenancy. And when you do leave the property, it's then the standard practice that you won't be compensated for those improvements unless then you take specific legal action around perhaps, if you want, undue enrichment for the landlord who has now gotten an improved property through your investment. But generally speaking, such improvements are not allowed, and there is case law that states that even when you do take the legal route, if you were aware of the principle that improvements are not allowed, and you go ahead and make those improvements, then you may not be entitled to recouping those investments.
Okay, the person just continues saying that the brother is not a lawful executor, but he's a good man. He wants to help us buy the house.
I think the first step would obviously to try and ascertain who the executor is, and have some kind of communication with the executor, maybe sign a new lease agreement with a new executor, because I mean this is a deceased estate, and that should be eye-opening to the tenants, because I mean the owner is no longer is no longer alive, is deceased. So the first point is to try and communicate with the executor, possibly sign a new lease agreement and take it from there. I mean, you don't want to spend a lot of money that you can't recover or recoup at the end of the day. I mean, my colleague is correct when she says that you're not allowed to use money on the property, maintain the property, if you're not granted permission to do so, most especially in this scenario where you won't be able to recoup the monies, or maybe you might even have to go through litigation to try and recover monies that you have spent on a deceased estate. And also you don't know how liquid that deceased estate is in terms of profits and losses and so on. You might become a creditor to the estate and so on.
Okay, so the person continues in saying there is actually no executor. The brother is the only one left behind, in other words.
All right. So in this case, then the brother would need to be in possession of, at the very least, a letter of authority.
Okay.
They may not be in possession of a will because not everybody leaves a will
behind.
so in terms of intestate succession, if the brother's the only surviving family member, then evidently the assets would fall to him. But also he would need to make that official by going to the master's office and obtaining that letter of authority, which then would give him that documented authority to deal with the deceased estate. So at least they would be able to verify using that document.
Mpho Raboeane also in studio with us together with the Deputy Chair of the Rental Housing Tribunal, Sibongile Morara, who also speaks to us this evening about really the function and also how and what the role is in terms of the Rental Housing Tribunal. If you have any questions, 0786 10 11 12. Now I want to come back to some examples of unfair practices, but not just from the landlord, also from the tenant. So let's say, for argument's sake, what then is unlawful from the tenant side, and whether a rental housing tribunal will step in? Because we discussed what would be unlawful in terms of the landlord, and that of course is failing to maintain the rental property, fails to refund your deposit, etc. But what from a tenant's point of view can the landlord do when the landlord goes against whatever the case may be?
Okay, so let me start by giving examples. I think the first one is a failure to pay rental, because that's the biggest one that people are currently struggling with, considering the economic situation with COVID and so on. And also a failure to accept notice to vacate. We know that landlords are struggling to give their tenants notices to vacate and so on. And also, I think the third one, sometimes you find landlords struggle to even enter the rental premises, and in those situations, I mean, they could lodge a complaint because they are allowed to get access to the rental property, even though it is rented to a tenant. So there are various also harassment issues between landlords and tenants. So landlords are also allowed to lodge, I think, those kind of complaints.
What happens if you fail to accept notice to vacate? If the tenant doesn't want to accept notice to vacate, then what can the landlord do in this case?
Well, firstly, I think we first have to establish whether the notice is in fact lawful. But if it is a proper notice to vacate and the tenant is just being obstinate by not accepting a lawful notice to vacate, then as my colleague has said, they would have recourse in terms of going to the Rental Housing Tribunal. And I think we've described the process earlier. It would undergo an investigation, so the tribunal would verify the facts of the matter, and then they would advise whether or not such a matter would be fit for mediation, where they sit down around the table and discuss the issue, failing which it would go into hearing for adjudication.
Mr. Morara, you want to add to that? Okay. Here's one more comment or question. When I started renting this particular place, I'm here now for almost 2 years, the agreement was, there was no agreement with regards to how many cars I can park in the parking bay. And now that I have 2 cars, the landlord says that I'm only allowed 1 car, but this does not state on the lease agreement.
Okay, that's interesting. Look, it depends. Once again, it's all about communication. If the lease agreement is silent on the number of cars the tenant can park, I think the best way to do it is to approach the landlord and saying, I have a second car now. What will be the terms? Should I pay for the additional car? Because, parking costs money in certain places. So the first point of call is to communicate and find out if this will alter. In any way, this alters the lease agreement. The lease agreement is silent on the parking issue. So I think the best way to go about it is to try and amend the lease agreement and incorporate the parking issue or agreement around that.
Okay. To those that are trying to call in on the 0786 number, please give us a call on 021 699 1786. That number again at 021 699 1786, or you can simply forward your question to 0786 10 11 12. Now, is there any particular amount that the rent can increase by?
Normally, it's standard practice that the rental increases by 10% on an annual basis.
Okay.
But we have seen that rental can increase by less than that,
Okay.
or more than that. So, yeah.
Okay. Anything you want to add?
Oh, no, I was just reflecting on a previous matter where we've seen something ridiculous. Rental increase going from around 40-something%, and more recently we've seen a matter where the rental would go up by over 1,000%. So it's quite vast, but Ms. Morara is right. We generally see lease agreements stating a 10% annual increase, and I think that's the accepted practice.
Now, in terms of the rights of the landlord when they want you off the property, if let's say they've already given you notice of having to leave and you refused that, etc., but you haven't done anything, right? Now, what happens? What rights do they have? And I know that they can't take the law in their own hands, but what right do they have in terms of getting you off the property?
So after a notice to vacate, the next step, if the tenant remains on the property, would be to undergo an eviction process through the courts. So the landlord then has recourse through the courts by making an application for that tenant's eviction. And I'm sure we've gone through the eviction steps on this program before, but simply put, the landlord, either through a lawyer or if they are skillful enough themselves, would have to serve the tenant with a notice calling them to court to argue this eviction matter. And in the founding affidavit, the landlord would then have to set out the reasons for wanting the tenant off the property, which could simply be that the landlord is the owner and would like to have possession of their property. And after that, the courts would consider the merits, whether or not the tenant has a case in terms of opposing the eviction. But where that is not so, courts do tend to grant eviction orders as long as it does not result in homelessness.
Okay, so here's one more question. I've signed a lease agreement of 1 year renting at this particular place, and now in last month the landlord came to say that her son will be returning from Johannesburg and she needs the place emptied, and I have until the end of the next month to vacate. Is this allowed?
Just repeat the notice period that was given to him.
Last month I was told that I need to vacate by end of next month.
So that's, what, 2 months?
Allowed?
That's more than sufficient in terms of the law.
But remember that this person says that they signed a 1 year agreement.
Oh, so this is
That
early
is-
termination.
Yes.
I see. All right. So we also need to remember that both parties are entitled to terminate the lease
Before the lease ends.
before the lease ends, but this is regulated by the provisions in the lease. So the lease will dictate under what circumstances the lease can be terminated by either party and what steps would need to follow, usually the notice period and all of that. So the first port of call, as with everything else, would be the lease agreement. Secondly, the law does allow for a landlord to terminate the lease agreement in specific circumstances or situations. We usually see this in instances where there has been a breach of the lease agreement. So where one party hasn't upheld the conditions of the lease, for instance, the payment of rent and all of that. And there it would be clear that the landlord is then entitled, because of the breach, to then cancel the lease.
Sure.
So it depends again on what the lease agreement says about early termination and what the consequences thereof would be.
So what advice can you give to this person in terms of what they can do? Because let's say, for argument's sake, that although the notice period is valid, they don't find accommodation in time. What happens? Because you've set yourself out that I'll be here for a year. What do you do then?
Look, obviously they cannot be evicted without a court order. So if they don't find an alternative place to stay, I mean, I assume they'd still be in possession of the property. And if the landlord tries to evict them without a court order, they may approach the Rental Housing Tribunal with a spoliation application. If there was a lawful lockout, sometimes landlord change the locks and so on. So they may approach the tribunal if it comes to that.
Okay. Here's one more question rather. My tenant is now staying 2 months in our flat. He asked the flat for his wife and child. Now we found out he's subletting our flat and he didn't sign the lease agreement yet. What can I do?
Okay, so the written lease agreement is not yet signed. But if the written lease agreement is not yet signed, they at least do have a verbal agreement. I assume that the rental is being paid on time, so there is a lease agreement in place. So if the tenant has now decided to sublet without permission from the landlord has a right to ask the new tenant to leave the premises. I mean, it's not allowed, it's unlawful.
Okay. Now we are running short on time, and there are some questions with regards to how do they get hold of the Rental Tribunal, the Rental Housing Tribunal, and also, of course, we will be giving you some details at the end in terms of the Ndifuna Ukwazi Housing Clinic line that you can contact. But in terms of getting in touch with the Rental Housing Tribunal, how can people do this?
Okay. They can walk in at 27. That's the oldest way of doing it. It's walking in at 27 Wales Street, and they'll have a help desk there, information office, and they can ask all the questions they would like, and they can lodge complaints. Alternatively, they can file a complaint via our email address, and I can give the email address. It's rht.dispute@westerncape.gov.za.
rht.dispute@westerncape.gov.za.
Yeah.
You have it. So it's 27 Wells Street, and I would suggest you walk in and you ask for help and advice, whatever the case may be. But also you can lodge your complaint to rht.dispute@westerncape.gov.za. And then, of course, you can also contact or go to www.evictions.org.za. And then the Ndifuna Ukwazi Housing Clinic line can be contacted at 062 352 9372. That's 062 352 9372. You may also email ntombi@nu.org.za. Before we forget, there's of course they are still continuing, and I think it started yesterday, the 18th of May. That was Wednesday. The Advice Assembly, the 10-week program that is happening between 5 and 7 p.m. at the Bertha House, 6769 Main Road in Mowbray. And if you want to learn more about what governs evictions, the law that governs evictions, this can be done at no cost. It's at Bertha House, 5 to 7 p.m. every Wednesday. It's a 10-week program. It started yesterday. Contact the number 065 993 1324. That's 065 993 1324. Or you can email yusra@nu.org.za. That's YUSRAH@nu.org.za for any further details. And that's, of course, if you're feeling threatened by your particular landlord. It's been lovely being in your company once again, Mpho, and also Mrs. Morara. It's lovely having you on the couch this evening.
Thank you.
And I do hope that we'll have another opportunity to do this again.
Always. Thank you for having us.
Thanks so much. And that's how we come to the end of On the Couch for this evening. Stay tuned to Radio 786. And from myself and my guests, we bid you assalamu alaikum wa rahmatullahi wa barakatuh.